Okay, Rule 121, New Trial or Reconsideration, Section 1, New Trial or Reconsideration. So, at any time before judgment of conviction becomes final, the court may, on the motion of the accused or its own initiative, but with the consent of the accused, grant a new trial or reconsideration. So, bakit kailangan yung consent ng accused? Kasi, the accused may be satisfied with the conviction. So, kung satisfied na siya sa conviction, gusto niya talaga makonvict, o di, baka ayaw niya na ng new trial and reconsideration. So, the grounds for new trial under Section 2. The court shall grant new trial on any of the following grounds. There are errors of law or irregularities prejudicial to the substantial rights of the accused have been committed during trial. There is a new and material evidence that has been discovered which the accused could not with reasonable diligence have discovered and produced at the trial, which if introduced and admitted would probably change the judgment. So, yung grounds naman for reconsideration, the court shall grant reconsideration on the ground of errors of law or of fact in the judgment which requires no further proceedings. So, Section 4 naman, the form of motion and notice to the prosecutor. So, the motion for new trial or reconsideration shall be in writing and shall state the grounds on which it is based. If it is based on newly discovered evidence, the motion must be supported by affidavit of witnesses by whom such evidence is expected to be given, or by duly authenticated copies of the documents which are proposed to be introduced in evidence. Notice of the motion for new trial or reconsideration shall be given to the prosecutor. Section 5 is hearing on the motion. So, when the motion for new trial calls for resolution any question of fact, the court may hear the evidence thereon by affidavits or otherwise. And Section 6, the effects of granting new trial and reconsideration. So, the effects, 1, when new trial is granted on the ground of errors of law or irregularities committed during the trial, all proceedings and evidence affected thereby shall be set aside and taken anew. The court may, in the interest of justice, allow introduction of additional evidence. When the new trial is granted on the ground of newly discovered evidence, the evidence already adduced shall stand, and the newly discovered evidence, as the court may, in the interest of justice, allow to be introduced and shall be taken and considered together with the evidence already on record. In all cases, when the court grants new trial or reconsideration, the original judgment shall be set aside or vacated, and a new judgment is rendered accordingly. So ito yung effect if na-grant, no? So what could be an effect if you filed, effect of filing, motion for reconsideration or motion for new trial? So if you filed any of this, it suspends the running of time to appeal. Suspends the running of time to appeal or obliterates the period to appeal. So, if na-deny ka sa MR or motion for new trial, the accused may still appeal within 15 days from the notice of denial of his motion or the new trial or reconsideration. So, anong tawag doon? Napes rule yun. Yan. So, sa Napes rule kasi, if your MR or your motion for new trial is denied, ayan, di ba na-suspend nga yung running of time to appeal, you are given fresh 15 days. Fresh 15 days to appeal. Ayan. So, di na kompleto. So, meron din kasing case. So, itong Napes rule kasi is a civil case. So, meron namang case yung Tatad case, Samson Tatad case, it promulgated na yung NAPES ruling is also applicable to this one, criminal cases. Yun. So, that ends Rule 121.